In the name of Almighty Allah, who is most beneficent and merciful. As a matter of fact, since a judgment of the Honorable Supreme Court has been circulated through all the registrars of the High Court for illuminating the minds of the judges of the district judiciary, particularly who are dealing with murder cases as well as other criminal cases, for our guidance, which pertains to a murder appeal which was dealt with by the Honorable Supreme Court of Pakistan a couple of months back, titled Muhammad Ilyas versus the State. The brief facts relevant of that very appeal pertaining to an occurrence which took place in the year 2007 at police station Ria Khas of district Narwal, and the time of occurrence was about 7:30 p.m. wherein Muhammad Ilyas was tried by the Learned Sessions Court and was convicted and sentenced to death, whereas his co-accused was no more prosecuted and rather acquitted. When the said accused preferred appeal before the Honorable Lahore High Court, the death penalty was reduced into life imprisonment. Since prosecution primarily had based its case through the ocular account furnished by one Muhammad Bhutta and Khidr Hayat. Muhammad Bhutta happened to be the real brother of the deceased as well as complainant of the case, and Khidr Hayat, who incidentally is serving as constable in the police station and deposed in the court as PW8, whereas that Muhammad Bhutta as PW7. To discard the ocular testimony of said two PWs from the accused side, one Muhammad Waris was produced before the trial court as a defense witness to establish the fact that since Khidr Hayat was a police constable and at the time of occurrence he was present on duty at his place of posting, i.e. police station situated in Lahore, whereas the occurrence took place at a faraway distance, means district Narwal. So it was a kind of proving the fact that Khidr Hayat has not witnessed the occurrence along with Muhammad Bhutta. This was the scenario in which the Honorable then High Court agreed with the version of the appellant and believed this very fact of absence of Khidr Hayat on the basis of that strong, valid and appropriate evidence. But even then, only the death sentence was reduced into life imprisonment. So to that extent, benefit was extended to the accused Muhammad Ilyas. However, complainant had not opted to challenge that finding of the Honorable High Court, but appellant preferred his appeal, which was accepted, and the accused was acquitted from the charges by extending him full benefit of doubt. This was the peculiar feature in which the Honorable Apex Court not only at the time of hearing appeal summoned that Khizr Hayat accused, particularly to my understanding, he was the person who furnished his ocular account along with complainant Muhammad Bhutta, and accused remained in jail for such a long time, and also passed on directions to the Sessions Judge Narwal for initiating proceedings under Section 194 PPC with respect to the conduct of that Khizr Hayat. How did he dare to become a false and fake witness, which means he was planted by the prosecution. But the Honorable Supreme Court also disbelieved the ocular account furnished by Muhammad Bhutta as well. There were some other discrepancies which were carefully taken into notice by the Honorable Supreme Court, pertaining to the fact that since it was a nighttime occurrence, although source of light has been mentioned, which was also referred in the site plan prepared by the investigating officer of the case, but that was not secured. So not only disbelieved the ocular account of both the PWs, but also this peculiar feature which I have mentioned of the mode and manner of the investigation conducted by the IO. In result thereof, this accused was acquitted, but at the same time, and on the one hand, the proceedings were got initiated against that Khizr Hayat, but also through a miscellaneous application bearing number 200 of 2019 was on the basis of same the matter was dealt with by the Honorable Supreme Court of Pakistan, and in pursuance to the same, these guidelines have been circulated to all the judges. Also, under Article 189 of the Constitution of Islamic Republic of Pakistan, the judgments and the verdicts of the Honorable Supreme Court of Pakistan, of course, are binding on all the subordinate courts, including the high courts. In this context, the Honorable Supreme Court dilated upon the issue by tracing back those peculiar rules and procedures regulating the courts conducting criminal trials, that how the appraisal of the evidence is to be made so that any innocent person may not be awarded such like punishments and be kept in jails for such a long period as the pathetic situation was confronted by Muhammad Ilyas, appellant convict in this case. To further elucidate the matter, the Honorable Supreme Court has also revisited that very principle which has gripped the legal circles, not only the trial courts conducting trial in criminal cases, especially the murder cases, as well as the Honorable Superior Courts of the country. In this regard, the first of all, the law which developed in the United States of America, United Kingdom, and even prior to those that era when the Indo-Pak was undivided. The foremost law, which was certainly more closer with that principle of falses in uno, falses in omnibus. But unfortunately, it has been observed by the Honorable Chief Justice of Pakistan, being author judge of this latest judgment, that has been made inapplicable, and another rule was crafted while appraisal of the evidence in the criminal cases, which is grain to be sifted from the chaff. Means, the first part, as the Honorable Judge has discussed, the falses in uno, falses in omnibus, indicating that peculiar feature of the deposition of the witnesses, especially of who have entered appearance in the witness box to furnish their oral testimony. And if the number of accused are 2 or more, then question arose. The proposition emerged before the court that, as per mandate of that principle, if the testimony of one witness to the extent of some of the accused, one accused has been discarded and disbelieved, whole testimony has been shattered. So the witnesses are not appearing in the court as a truthful witness, which too is against the injunctions of Islam and the teachings of Quran and traditions. So I again revert back to, just for the sake of reference, which have been found mentioned in this judgment by the Honorable, as referred by the Honorable Supreme Court of Pakistan. There are, from the American jurisdiction, it is regarding Stott treason trials and trials of Hamilton of 17th century, trial of Loghorn of the same century, trials of Coleman, wherein the complete benefit was extended to the accused on the principle of falsus, falsus in omnibus. So if some portion of the testimony of the witness has been disregarded, disbelieved, so it means the whole of his account, whole of his testimony would shatter. It is having great nexus with the principle of indivisibility, which means the evidence cannot be considered divisible, cannot be undivided. So it would affect whole the prosecution story. So the reference have been done again in this judgment. The Honorable Supreme Court of Pakistan has also taken into consideration the historical, religious, cultural aspects of the matters. The temperament, the behavior, the conduct of the people living in the subcontinent withhold the truth, and they come forward in a very blatant and flagrant manner, and they are always ready to tell lie before the court of law without adherence to not only Islamic teachings, but absolutely their conduct is unholy, unethical, immoral, and they are not shy of to further elaborate this aspect of the matter. The Honorable Supreme Court has also referred an article titled "Truthful Character of the Indian Witnesses," which was published in AIR, All India Reports 1945, General Part, by Thakur Prasad Dubey, who probably was a practicing lawyer or a judicial officer, who in a very comprehensive and exhaustive manner taken into consideration the peculiar circumstances prevalent in the villages, in rural areas and the urban areas of India, and while discussing this aspect of the matter, it is a common character of the people. So they normally in their routine life they used to say, "I'm not lying because I'm not in a court of law," which is reflective of the fact that they do not bother to speak lie before the court, and even in their social life, their domestic life, in normal manners, in their dealing with people. So they demonstrate in that manner, because he is not lying, because he is not before the law, just to reaffirm and re-verify and to satisfy any person with whom he is having some sort of dealing. So this situation has developed, that too well. While further making a distinction and applicability possibility of another rule and principle, grain to be sifted from the chaff, which has been taken into consideration while appraisal of the evidence by the courts, not only by the court of first instance, where demeanor of the witnesses is to be examined and judged very minutely, very carefully, so that an innocent person may not be convicted on the basis of that. A testimony of the perjurer, the fake and planted witness, particularly who are furnishing their ocular account, to make court understand that they are truthful witnesses. That is why the Honorable Supreme Court of Pakistan in this judgment took into notice the provisions contained in Pakistan Penal Code in the relevant chapter for initiating proceedings against such like witnesses who are perjurer and they have made their deposition in criminal cases absolutely on the false premise against wholly fabricated and distorted facts. And those provisions starting from section 194 and onward up to 211, particularly with reference to the offense of false evidence in criminal cases entailing capital punishment as postulated under section 194 PPC mentioned supra. It was also observed that these provisions, since are not being made applicable if any such like situation emerges, notwithstanding the fact that whole trial of criminal case is concluded, even in the cases where the accused persons are acquitted, but no headway is made by the trial courts to initiate criminal proceedings against planted and false witnesses, which too is a matter of grave concern and highly deplorable. So this is a kind of direction to the courts for adhering to these provisions, which have been rather made ineffective and redundant in a manner. So the inapplicability of principle of falses and falses in omnibus is also not being taken into consideration, mainly for the reasons that so far the law expounded by the Honorable Superior Courts of Pakistan, not only by the High Courts, but variable august benches of the Apex Court in previous years. The Honorable Supreme Court of Pakistan, this time, while revisiting those judgments which are mainly held and observed that a rule of criminal jurisprudence regulating the appraisal of evidence of the witnesses, grain is to be sifted from the chaff, which is undoubtedly a complete departure from the principle of falses falses in omnibus. This has been the consistent view of the Honorable Superior Courts. I am also of the considered view that this is that intellectual curiosity, wisdom, prudence, research-oriented approach of the Honorable Chief Justice of Pakistan, who has taken into notice the development of law in deciding the criminal cases by the courts starting from the trial court up to the Honorable Supreme Court of Pakistan. As many as 27, let me say, two celebrated judgments of the Honorable Supreme Court of Pakistan and the relevant operative part and portions have been taken into consideration, and the reasons enumerated therein for the guidance of the judges of the trial court and of the Honorable Superior Courts while dealing with murder affairs and the appeals. In those 27 judgments which have been referred in this esteemed latest verdict of the Honorable Supreme Court of Pakistan, the most, again, a distinction has been drawn by the Honorable Chief Justice of Pakistan while dilating upon the reasons which prevailed in the minds of the honorable judges, except that of a judgment reported in PLD 1951, Lahore 66, and that judgment was authored by then Chief Justice. Brief resume of cited judgment was that there were 5 deceased persons of an occurrence, and originally case was registered against as many as 13 persons. Almost 9 or 10 were tried. They were awarded death penalty for causing murder of 5 persons. When the criminal appeals and murder reference were taken up for hearing by the Honorable High Court, out of said convict accused persons, 2 were found to be not present at the place of occurrence and who had taken a plea of alibi. That plea of alibi was believed. But certainly the set of witnesses which were produced in the court, who had furnished their ocular account, and these two persons were given benefit of doubt. In this manner, again it was reiterated by the then Honorable High Court and the bench headed by Chief Justice Professor Muhammad Munir. He is the same honorable judge who later years dealt with the constitutional matter and had endorsed the unconstitutional actions while dissolving the then assembly. And in the constitutional history of Pakistan, the renowned Maulvi Tamizuddin case is available, and we, being students of law, always go through that judgment when getting first-hand knowledge about the development of constitutional history of Pakistan. And very distastefully, that endorsement of the actions by Justice Munir is taken by the legal and constitutional circles in length and breadth of the country. However, in this judgment, in a satirical manner, the Honorable this court has pleased to notice that even in this case, where principle of falsus in and falsus in omnibus, although was not adhered to by this bench as well, and the rule of grain to be sifted from the chaff, but reasons were given. Whereas the Honorable Supreme Court of Pakistan in previous years, through numerous judgments, those are almost 26, 27 in number, find mentioned in this latest judgment. The Honorable Judges remained stuck with this perception that in our culture, in province of Punjab, in rural areas, due to lot many other factors, it cannot be termed, and that a witness would depose in the court, withhold the truth. That is why some portion of the testimony can be believed to the extent of one or two accused persons in the case, and for remaining accused persons it is liable to be discarded and disbelieved, which is a natural phenomenon. In similar fashion, a judgment reported in PLD 1959, Privy Council 24, was also exhaustively dilated upon. In this case, some accused persons were tried, they were awarded death penalty. When the appeal and murder reference came up for hearing before the Privy Council, it was held that the case was remanded for de novo trial. But no authoritative judgment was rendered. Whereas in the aftermath, till verdict enunciated through this esteemed judgment, rule of grain to be sifted from the chaff was extended full premium and credence by the courts in deciding criminal cases. To draw the inference that principle of falses in omnibus was altogether ignored in making appreciation and appraisal of the evidence. In this, to further substantiate by making that principle operational, and for adherence by the courts to the principle of falses in uno and falses in omnibus, the Honorable Supreme Court has referred some Quranic verses Quranic verses with respect to admonishing and condemning the command of Allah Almighty. If somebody gives false evidence to prosecute any offender or conceal the evidence available with him. And the crux of the matter is that even if one has to depose against his own parents and loved ones, relatives, he or she must not withhold the truth. Some teachings of Holy Prophet Muhammad, peace be upon him, have also been taken into notice in this respect. Consequent upon the principle of falses in uno, falses in omnibus has been restored in its full vigor, validity and applicability, while appreciation of the evidence brought before the court of law in any criminal case. And the numerous judgments already enunciated by the Honorable Supreme Court of Pakistan and High Courts on the principle of grain to be sifted from the chaff have been made non-existent. Emphasis has been given by the Honorable Supreme Court of Pakistan on Article 2, 2A, 227 envisages in the Constitution of Islamic Republic of Pakistan 1973, wherein Islam is not only the state religion, but no law will be made, rather promulgated in the country, which is repugnant to the injunctions of Islam. Before summing up my very humble submissions for sharing the excerpts of this celebrated and latest judgment of the Honorable Supreme Court of Pakistan, wherein whole the development of case law has been thoroughly traced back, rather revisited, and the significance of Islamic teaching have been elaborated, which are also in accordance with that Latin principle. Rather, that Latin principle of falsus in uno, falsus in omnibus is based on the teachings of Quran and Sunnah. However, at the same time, it would be absolutely unjust and against the facts and circumstances which have been prevailing in our society as a whole. If for appraisal of a witness in criminal case, this much strict view is taken, then it is also need of the hour to disseminate the teachings of Islam for the persons who are conversant with any such like eventuality where testimony is imperative and mandatory, but why they do not they do not want to speak the truth. There is also need of the hour to streamline the laws on this very critical issue, because courts have to interpret the laws so that the laws be made more consistent and in consonance with the aspect has also entrenched my mind. Very earnestly and honestly, that in a country which is highly under debt, everybody is aware of the fact that a newly born child is at a debt of lakhs of rupees, and still our government is craving for having loan from the International Monetary Fund and international financial development institutions like Asian Bank, World Bank, even just to run the day-to-day affairs. So I believe we do get our salaries from interest-based economies, and we pay back a huge interest. So can it be termed that we are fully abiding by the injunctions of Islam? So far, what ijtihad has been made, even for declaring the interest un-Islamic, Federal Civil Court had rendered a judgment so many years back, but yet there is a interest-based banking system in our country. And this is also grand norm of the Islamic teaching, that if some Muslim deals in interest-based transactions, it is a war with Allah. I am also mindful of the fact that it is also to be seen and examined in its true perspective, that the Quranic verses referred in this judgment are in what peculiar background and situations. Another question arises: if the judgment of the Honorable Supreme Court of Pakistan, larger bench of the Honorable Supreme Court of Pakistan, reported in PLD 2018, Supreme Court 595, wherein subjective and generalized approach regarding applicability of law has been discussed. And not the objective in nature. Let me very briefly refer. This judgment has been rendered by the Honorable Supreme Court of Pakistan through the larger bench comprised of 7 honorable judges on the multiplicity of the FIR, wherein it has been held that one FIR regarding an occurrence and set of accused persons against set of accused persons, venue of occurrence, mode and manner of occurrence. If any cross version is brought by the opposite party or improved version is brought by the complainant, it would be made part and parcel of that first FIR. But the moot point which also emerged as observed by the Honorable Supreme Court of Pakistan, that there should be a truth even if any stranger finds a dead body lying somewhere, he must report the matter. This is the job of the investigating officer and the police to dig out the true facts, to find the complainant or any loved one of the deceased of the case, trace the real culprits, and the objective and purpose of Section 154 CRPC meant for registration of criminal case is just to set the law into motion. Then question arises, is our police is so efficient, competent, fearless to reach at a truth, who even do not bother to just move a step ahead to vindicate the grievance of the aggrieved person. How in a criminal case, when they too have their own lot many excuses of non-availability of the transport, non-availability of the funds needed for accomplishment of the investigation of the case, visit of the place of occurrence, moving around for apprehending the accused person, to find out true witnesses of the occurrence. There might have been some distinguished features of the Narowal case, but there too is a strong probability that Muhammad Bhutta was genuine witness, but just to provide strength to the prosecution case, a plural account in form of testimony of Khizr Hayat was also brought on record. There may be another possibility with this angle, that his presence was marked at his place of posting, i.e. police station Lahore, which fact was proved by Muhammad Waris Muharrar to extend benefit to the accused as DW, as defense witness. But Khizr Hayat might witness the occurrence and had slipped away from his place of posting and covered that venue of occurrence situated at Narwal. Even if he is a planted witness, along with Muhammad Bhutta, whose testimony has also been disbelieved by the Honorable Supreme Court of Pakistan, had made a genuine effort to convince any stranger or any person who had seen the occurrence genuinely of causing murder of his brother by Muhammad Ilyas accused, but that genuine witness was not ready to become a witness in the case. Can the principles of foreign jurists be made applicable in this country in its true perspective and context, when we are still living in a society where there is class discrimination, poverty-stricken people, fiefdom and feudalism is still at its peak. Even after 2010, the period when the Honorable Chief Justice of Pakistan was elevated as Judge of the Supreme Court, some judgments having reference in this latest judgment were delivered, wherein rule of grain to be sifted from the chef was fully made applicable instead of that original rule of falsus in uno, falsus in omnibus. Yet much can be discussed for bringing reforms in our criminal law regime. But I leave it to the jurists, academicians, honorable judges of the Superior Court for further elucidation in this regard. Thank you very much.